Hi, I'm Ben Weaver, Illinois attorney and founder of 23 Legal. I help folks around the Chicagoland area buy and sell houses. I also help people with wills and trusts and other estate planning documents. And today, we're going to talk about page 7 of the Illinois Multi-Board Real Estate Contract 8.0. So let's get started. Page 7 begins halfway through paragraph 17. Now, if you watch page 6's video, paragraph 17 is a paragraph about HOA and condo association documents. So the first two paragraphs of paragraph 17 are on page 6. Basically, the seller agrees to provide the association documents to the buyer. In addition, the seller also agrees to pay any monthly assessments or special assessments that are due before closing. All right, that's on page 6. On page 7, you have a few more association paragraphs. So paragraph 17C begins page 7. Paragraph 17C says that if the seller learns of any new or proposed special assessments before the date of closing, they have to notify the buyer of those proposed or agreed upon special assessments, and the parties have a chance to discuss it. If they can't agree to the terms of that special assessment, either party has a right to cancel the contract. All right, paragraph 17D says that the seller is responsible for ordering the association documents within 10 business days of the contract signing. Now, usually, since a lot of property managers charge money for those association documents, the seller usually doesn't do it until attorney review is completed. However, within the contract, it does say that the seller should order them within 10 business days of signing the contract. Paragraph 17E says that if the buyer does not agree or does not approve of the association documents, there is a clause where the buyer can cancel the contract if needed. This is important because there may be a rule, say, for example, if the buyer is purchasing the house or the condo, whatever, they're buying it because they want to rent it out, and then they find out there's a rule prohibiting rentals. Well, paragraph 17E gives the buyer the chance to cancel the contract if needed. Paragraph 17F goes into insurance and common insurance for the association. If needed, the seller agrees to cooperate and help the buyer's lender out with insurance documents, common insurance documents for the association. Paragraph 18, the deed. Paragraph 18 goes to the terms of the deed that the seller agrees to provide to the buyer. At closing, the seller will provide a warranty deed to the buyer. Paragraph 19, municipal taxes, transfer taxes, governmental compliance. Paragraph 19A says that the parties, both buyer and seller, agree to cooperate with any local village or city transfer requirements. So some cities, some villages require the seller to purchase a transfer stamp or have a final village inspection or maybe pay the final water bill, do something like that in order before they will agree or approve of the sale to the buyer. However, other villages, other cities require the buyer to go to the village and pay for a transfer stamp before the village will approve of the sale. So, paragraph 19A says that the parties agree that they will cooperate with whatever the local ordinances are for that municipality. Paragraph 19B goes into taxes. The seller agrees in paragraph 19B to provide what they call a FERPTA statement to the buyer. Now that gets into some more complicated tax issues, but the bottom line, it's a good deal that the buyer receives that from the seller at closing. It helps protect their interests, and it's noted in the contract that the seller agrees to provide this document to the buyer at closing. Okay, the last paragraph on the page, paragraph 20, title. Title is very specific to each state around the country. So people will hear a lot about title because they'll see it talked about in movies. They'll talk about what title is like in California or maybe they'll hear a story about their cousin who just bought a house in Oklahoma. But each state has a different way and traditional way of doing things with title. In Illinois, the seller provides title insurance to the buyer. So what that means is that when the contract is initially signed, the seller will find the title company and they will contract with that title company to provide the title insurance, which is an insurance to make sure that by the time we get to closing, any issues with the ownership, say for example, does the seller have a mortgage they need to pay off? For example, is the seller's ex-spouse still on the deed and we need to find that bum and get them to sign a release so that they waive their interest in the house? Any issue like that is taken care of by the time we get to closing. Other states, aside from Illinois, will have the buyer responsible for that. And other states have a mixture. But in Illinois, the seller is responsible for providing title insurance to the buyer. Also in Illinois, the title insurance company plays a role in the actual closing. So when we get to closing, we go to the title insurance office, and the title insurance company acts basically, they're the middleman. They're talking to the lender, they're talking to the county to record the deed. They're kind of acting in a role where they're coordinating everything to make sure that the closing goes smoothly. So in Illinois, the seller agrees to provide title insurance to the buyer, but by the time we get to the closing, both buyer and seller will have fees associated with it, and both parties pay some fees to the title company. Well, there you have it. Page 7 of that multi-board Illinois Real Estate Multi-Board Contract 8.0. I'm Ben Weaver. If you have any questions about page 7 or anything else about the contract, leave it in the comments below. I'll see you on page 8 in the next video.